Hello and welcome to another edition of Trial Watch with me. I'm N.Starow, the Viking lawyer, the Walmart Gandalf. A dear child has many names. Now, we have been waiting for this. We gave a lot of hope in the Georgia Supreme Court when Weinstein filed a writ of mandamus to them. They have come with a decision. And at first, I was disappointed. Then I noticed something. But first, let's go through this. Oh, sorry. The Honorable Supreme Court met pursuant to adjournment. The following order was passed. DeMonte Kendrick v. Juror Glanville, Chief Judge. Petitioner DeMonte Kendrick, who is facing trial on ending and other charges in Fulton County, filed directly in this court an emergency motion seeking original relief in the form of mandamus against Chief Judge Juror Glanville and the stay of proceeding. Kendrick filed in the Superior Court a motion to recuse Chief Judge Glanville after he became aware of an alleged ex parte meeting on June 12, 2024, between the judge, the assistant district attorneys, a state's witness, and the witness attorney. Chief Judge Glanville did not refer Kendrick's motion to recuse to another judge, see Uniform Supreme Court Rule 25.3, and instead decided the motion himself and denied it. That number down there means it's a footnote. This will become important. Here, before seeking the original mandamus relief from this court, Kendrick is required to show that he first sought and was denied access to the proper channels for seeking relief in Superior Court. And Kendrick has not made such a showing, as he admits that he has not filed a standalone mandamus petition against Chief Judge Glanville in Superior Court. Although Kendrick expresses concern that filing a mandamus petition in Superior Court would be futile because the petition would be assigned to Chief Judge Glanville, that is not so. As explained in Brown, if Kendrick were to file a mandamus petition in Superior Court naming Chief Judge Glanville as the respondent, Chief Judge Glanville would be disqualified from presiding over the matter. A different judge would consider Kendrick's petition, and either party may appeal the final decision. See Brown 251 Georgia at 437. Accordingly, Kendrick's emergency petition for writ of mandamus and stay of proceedings is dismissed. Now, this is lawyer speak. There is some hidden clues here, in my opinion, to what they feel about Judge Glanville. As expressly here. They hear that in the meaning, although Kendrick expresses concern that a filing of mandamus petition in Superior Court would be futile because the petition would be assigned to Chief Judge Glanville, that is not so. That is the Georgia Supreme Court more or less saying to Glanville and to the attorneys that he can't. Which removes that option now for Judge Glanville to try to take it on himself. This is Georgia Supreme Court. It's not a decision, but it's underhanded told to him, don't you dare make another boo-boo. Don't you dare. So they are saying out loud, if you file it in Superior Court, which is Fulton County, he is disqualified from handling the matter. And if if they reach a conclusion that, oh, Judge Glanville did no wrong, then come to us. And then we go to this again. Remember, I said, oh, it's a footnote. Oh, yes, there is. There is a footnote. USCR 25.3 provides when a trial judge is presented with a motion to recuse or disqualify, accompanied by an affidavit, the judge shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and the legal sufficiency of the affidavit and make a determination, assuming any of the facts alleged in the affidavit to be true, where the recusal would be warranted. What they did here is not in the original text. In cursive here. This is their actual highlighting to everybody involved. Read this. It is found that a motion is timely, the affidavit sufficient, and that recusal would be authorized if some or all of the facts set forth in the affidavit are true. Another judge shall be assigned to hear the motion to recuse. Let me repeat. If it is found that the motion is timely, it is. The affidavit sufficient, it is. Judge Glanville himself said that. But then he changed the wording, so to speak. He didn't find it sufficient. The facts alleged. But here's the thing. He can't make that determination. He has to assume the facts alleged in the affidavit to be true. He has no choice, but he gave himself that choice. This is, again, the Georgia Supreme Court telling everybody involved, this is the law. These are the rules. But if we are going to handle this, you need to cross all the T's, dot all the I's. You have to go through Superior Court, as in Fulton County. You have to. Because if they are going to make a ruling in the Georgia Supreme Court, every step of the way. So when I first read this, I was on it. But then, when you read the fine print, the footnote, the wordings, the noggin kicked in and, oh. So yeah, sadly, this will take more time because now they have to go through Superior Court. Then, after a decision is made, they have to make an appeal. What will happen then, since the underlying act is murder? Georgia Supreme Court has taken precedence. They already said that in the bond about Mr. Steele's criminal contempt. So sadly, we have to wait a bit longer, but it's a step forward, I believe. It's a step forward, tiny, tiny step forward. The Georgia Supreme Court clearly states this is the law. These are the rules. Thank you all for showing up for this short little video where I give you my thoughts. I'm Nick. I'm your favorite Viking lawyer, the Santa Laws, or Walmart Gandalf if you wish. Have a nice day, and I will see you Friday tomorrow on a full stream on what happened during this week in the Young Thug trial. Okay? Thank you. Bye-bye.